Welcome to Black Hat Windows Security Conference 2002, held February 7th through the 9th in New Orleans, Louisiana. The following videotape was recorded live at the conference and produced by the Sound of Knowledge Incorporated.
Early in the morning.
Thank you. I thought I'd be all right going first, but I see that really I'm actually following last night, so I have a tough act to follow. Welcome to Black Hat. Imagine for a moment that after Halvar's presentation this afternoon on Windows NT exploits, FBI agents arrest him and charge him with a crime. Imagine that they also have a warrant for his computer. They search it, they find copies of security and auditing tools on the hard drive, so they seize those programs and destroy them. Imagine a world where coming to this very conference is illegal. We are standing on the doorstep of that world right now. In 1999, a 15-year-old Norwegian wrote a program that would let him play his DVDs on a Linux machine. He published the program on the internet. Several news organizations, including the New York Times, linked to that program when reporting on the story. The movie studios sued one of those magazines, 2600, something of the low-hanging fruit compared to the New York Times newspaper, and shut the story down. The Norwegian prosecutors charged that kid with a crime this year, actually last month. In 2001, the record industry threatened computer scientists with a lawsuit if the scientists published a paper describing the flaws in SDMI, encryption tool that the industry favored to regulate how and when people could listen to digital music. The threat stopped the scientists from presenting paper at an academic conference. In July of 2001, a Russian programmer was arrested in Las Vegas after DEF CON for writing a tool that defeats the anti-copy protections for Adobe eBooks. What is happening here? The 2600 case, Professor Felton's case, and the Sklyarov case all involve situations where people were silenced by a new provision of the law, a section of the Digital Millennium Copyright Act called the Anti-Circumvention Provisions, or simply Section 1201 for the division of the law which describes the restriction. Under Section 1201, it is illegal to circumvent technological protections of copyrighted materials. It is also illegal to make or distribute any technology or service that is primarily used to circumvent a technological measure that effectively controls access to a copyrighted work. So everybody got that? Okay, good, because there's a quiz at the end. Essentially, this means that any program which is primarily good for getting around technological copy control measures is now illegal to distribute. DCSS, the program that the Norwegian kid, John Johansson, wrote, decrypted DVDs and let you play them anywhere, as opposed to just on the machines that the movie companies said you could play them on. By linking to it, 2600 was considered to be distributing the technology. A New York federal court enjoined the magazine from doing so, and recently the Second Circuit upheld that decision. At the appellate level, the 2600 side was argued by the dean of Stanford Law School, eventually the woman who is my boss, but nonetheless we lost. Professor Felton and his colleagues weren't even distributing a program. They were simply publishing information that showed security weaknesses in the record industry's digital rights management software, SDMI. But apparently the record industries considered that information about how SDMI failed to work properly as a recipe for breaking SDMI. And the DMCA is so broad and vague that the record companies could credibly claim that publishing the paper or presenting it at an academic conference violated the law. Dmitry Sklyarov wrote a program that was entirely legal in Russia, but because his employer distributed it over the internet, and because Adobe had some sway with the local prosecutors, he was charged in the United States with a United States crime. How did we get to this point? The answer to that question lies in history. The legal history of the protection of intellectual property, the economic history of the growth of the content industries, the movie studios, the record companies, and the software companies, and in the social history of the ethics, in the social history of the development of ethics about property and social rights. This morning, I'm going to tell that story and to draw the path we took to get to the doorstep of the world where black hat could be illegal. I'll explain the growth of the power of the content industries, the development of copyright law, and the dwindling of civil rights and the rights of citizens to use the information around us. I'll discuss how the content industry has used its legitimate concerns about digital technology and how it enables copyright infringement to promote a copyright maximalist view in the law, both internationally and domestically, and to promote that view in the minds of the public. We'll talk about the interaction of legal and technological controls of content and examine the modern and potential future implications of the anti-circumvention provisions of the Digital Millennium Copyright Act. Then I'll come back and I will ask you whether the future that I've described will be our future or whether it is something that we and you can do about it. Let's start with the United States Constitution, one of my favorite places to start. This is not the beginning, but it is our beginning, and it's a good place to start the story of copyright. The framers of the Constitution gave Congress the right to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. The founders of this country wanted a system that would reward innovation and creativity, and a system that would promote public discourse and the free exchange of ideas. Original creative works were automatically in the public domain, unless the creator took steps to copyright. If copyrighted, authors and inventors controlled their works for a period of 14 years, a limited time, and they had an option for a one-time renewal. The creator, once copyrighted, then the creator had our traditional copyright rights, the exclusive right to reproduce, distribute, perform the work, or make derivative works. After that 14-year period of control, the work would pass to the public domain for people to use freely. Today, I'm not so sure that people understand the value of the public domain because we've so associated the idea of free with the idea of something being worthless. We have accepted the primacy and the importance of power and control. Here, though, when I talk about the public domain or I say free, I don't mean free as in not worth anything. I mean free as in free to use, and that this public use or the ability of the public to use it creates a public value for all, not for one. Cultural, economic, scientific progress depends on the free exchange of ideas and shared public resources. To give you an idea of the importance of the public domain, I'm going to read a brief paragraph from Larry Lessig's book, The Future of Ideas. Now, he really is my boss, but he actually does say this better than I could say it, so I'm going to read what he had to say about it. Free resources have always been central to innovation, creativity, and democracy. The roads are free in the sense I mean. They give value to the businesses around them. Central Park is free in the sense I mean. It gives value to the city it centers. A jazz musician draws freely upon the chord sequence of a popular song to create a new improvisation, which, if popular, will itself be used by others. Scientists plotting an orbit of a spacecraft draw freely upon the equations developed by Kepler and Newton and modified by Einstein. Inventor Mitch Kapor drew freely upon the idea of a spreadsheet, VisiCalc, to build the first killer application for the IBM PC, Lotus 123. In all of these cases, the availability of a resource that remains outside the exclusive control of someone else, whether a government or a private individual, has been central to progress in science and the arts. It will also be central to progress in the future. So in the beginning, public domain was the default and copyright was opt-in. Far from conflicting with free speech, people thought copyright law was the engine of creativity. By guaranteeing authors the ability to profit from their work, the scheme established a financial incentive to create. And what could be more American than that? We would have more paintings, more novels, more music, because it was worth the artist's while. Copyright law gave authors control over the way ideas were expressed, but not the ideas themselves, so the public was still free to discuss whatever it liked in the marketplace of ideas. Copyright's purpose: to promote science. The persons in whom rights were granted, authors and inventors, and their duration of rights for limited times, harnessed private financial incentive for the public good. The law has evolved since then, and control is now the default. A work passes into the public domain only after the author is dead and 70 more years have passed. The distinction between control over expression and over ideas is blurred. Mathematical algorithms are copyrighted, though math is a language for the expression of ideas. Symbols are copyrighted, though a picture is worth 1,000 words. Along with copyright, trademark, and patent protection, along with the copyright protection, trademark and patent protection have also expanded. And the fruit of intellectual pursuits, ideas that you may come up with during your workday, are now someone's property, usually those the property of your employer. The initial balance that was struck between owner control, free speech, and the public domain is now out of whack. And copyright lasts for too long. Public concerns have become second to the idea of profit maximization. Technology that perfects control for the owner may not be tampered with, even if the public is deprived of fair use scientific, educational, or free speech rights. Why did this happen? There are many reasons for this shift, but to my mind, the primary, number one, most important reason is the growth of power of the copyright industries, both financial power and its corollary, power with the government, political power. And that these industries have emphasized profit maximization over all other social values in their efforts to lobby Congress. They have successfully convinced lawmakers and the public that intellectual creations are property in the same way that a car is property, that copying a work is stealing a work, and that copying is a public offense, a crime that should be prosecuted with public taxpayer dollars. Instead of the authors and inventors imagined by the Constitution, we now have billion-dollar software companies, movie companies, and record industry giants. These conglomerates collect the creative work of others and profit from the economy of scale in publicizing and distributing these works. AOL Time Warner, for example, is one of the top 5 United States or global leaders in film production, TV production, cable TV channels, movie theater ownership, book publishing, music, and magazine publishing. It had over $37 billion in revenue in the year 2000. Disney, $25 billion. Sony, $57 billion. Vivendi, $13 billion. The Recording Industry Association of America, the RIAA, represents roughly half a dozen major record companies and the artists on their labels, and control approximately 90% of the distribution of recorded music in the United States. With this intense economic power comes immense lobbying power. According to a 2000 report by the Center for Public Integrity and the Columbia Journalism Review, the 50 largest media companies spent $111.3 million to lobby Congress and the executive branch in 1999. The amount of money spent on lobbyists went from $24 million in 1996 to $31 million in 1999, just money to pay lobbyists. As a result, the content industries are very successful in promoting their agenda to Congress and the executive branch. And in the policy arena, they are able to promote their interests as if those were the only interests about which policymakers should be concerned. Let's look at one of those successes, the extension of the term of copyright. In 1790, Congress protected copyright for the constitutionally permissible limited term, 14 years, with an option for extension to another 14. After that, the work would pass into the public domain. This limited time struck a balance between incentivizing creators and the public interest in building on and using the creations of others to further the arts and sciences. The duration of the term of copyright and the copyright scheme in general remained relatively stable until the 1970s, when Congress began to amend copyright statutes with much greater frequency, and also began to steadily increase the length of term of copyright protection. The Sonny Bono Copyright Term Extension Act of 1998 changed the copyright term again, and now it is 70 years plus the life of the author. The term for works for hire, that is works that someone creates while under the employ of a corporation, is now extended from 75 years to 95 years. This term makes little economic or constitutional sense. From an economic view, most profit is reaped when the work is new, not 70 years later. Speculative profits in the distant future, long after one is dead, are not a significant incentive in the decision to create. The musician or inventor wants to feed his family in the next 5 years, not 70 years after he's gone. Also, if the purpose of the copyright law is to incentivize new works, why would Congress extend for 20 additional years the term of copyright for works that are already in existence? There is no incentive to create there, the works already exist. The reason is that it's worth it to the copyright industries that amalgamate thousands and thousands of works, because even a tiny revenue stream multiplied by thousands and thousands over many, many years is better than nothing. It no longer has to do with making sure that the author profits from his work, and it no longer has to do with striking a balance between the owner's interests and the public's interest, the democratic values of our society. We pay the price to ensure this elongated revenue stream for the copyright industries, and the public domain suffers. Librarians and scientists have lobbied Congress on this issue, but compared to the corporate copyright interests, they simply don't have the money or the access to really put this point forward as it needs to be. In the past, the RIAA has argued that you can't make taped copies of your CDs to play in your car, or digital copies to play on your computer or on an MP3 player. Companies don't want you to make backup copies of video games that you have purchased. These campaigns are primarily about control. These companies want to control where and when you listen to music and movies that you own. And if you want to listen somewhere else, they want you to pay again. Let's take the VCR as an example. So how many people here own a VCR? Okay. How many people here know that Universal Studios tried to stop the VCR from being distributed? Okay. So in 1976, Universal Studios sued Sony for making the VCR. Actually, it was Betamax, and they called it a videotape recorder, but it's essentially the same thing. Since the VCR, Betamax, was used for making unlawful copies of TV shows and could be used for making unlawful copies of movies, it enabled copyright infringement. And Sony, which made this devil machine, knew when it sold it that people were using it to make these unlawful copies of TV shows. They sold it anyway, and they profited from the sales. So Universal Studios sued them for contributory copyright infringement and for vicarious copyright infringement, profiting from illegal activities of others that Sony was aware of. By 1984, the case, which is called Sony Betamax, made its way to the United States Supreme Court. And in this case, the United States Supreme Court rejected Universal Studios' side. The court said that because the VCR was capable of other non-infringing uses, it could not be banned, and that Sony was not responsible for the illegal uses to which other people put their product. The court said, "The sale of copying equipment, like the sale of other articles of commerce, does not constitute contributory infringement if the product is widely used for legitimate, non-objectionable purposes, or indeed is merely capable of substantial non-infringing uses." So that was one part of the case. But another kind of more interesting part of the case is that the court knew that people were making illegal copies of TV shows to watch. But essentially what the case also ruled was that you could make these unauthorized copies for the purpose of watching TV shows at a different time when you were available. In other words, that the idea of time shifting, watching the TV show not when the studio wanted you to watch it, but when you wanted to watch it, was a fair use, that it made it okay to make these copies. Imagine what the world would be like without the VCR. Harried parents would never see movies. Many of us would miss The Simpsons on a regular basis. The TV and movie industry has not seriously suffered because of the VCR. And yet, the rule of Sony Betamax is in serious trouble. In the Napster case, attorneys there raised the same argument, saying that because the file sharing technology was capable of substantial non-infringing uses, in other words, transferring music that's in the public domain or music that people had not wanted to control but had released freely to the public, the music industry should not be able to shut the technology down. Well, they lost that argument, and Napster is essentially dead now, and the movie companies have moved on to try to slay peer-to-peer file sharing technology companies like Music City and Grokster, which, in full disclosure, Stanford Center for Internet and Society is co-counsel in that case, and we represent Grokster. Why are courts more receptive to content industry arguments against Napster than they were to arguments against the VCR? Well, in addition to the growth of the money and power of the content industries, one reason may be that Congress recognizes the special problem that digital technology poses for companies that make their money distributing and controlling content. Digital technology makes copying a much greater concern. The 100th copy is as clear and good as the first copy was. So with records and tapes, there was always an incentive to buy the original because it just sounded better. But with digital technology, there is no sounds better incentive and you wouldn't necessarily want to buy the original unless you were looking for the cover art or the liner notes or something like that as well. Also in the networked world, unlimited numbers of unauthorized copies can be sent around the world quite easily. From the beginning, copyright owners saw the potential and the danger of the new technology. They could use the digital network to lower their distribution costs. It would be cheaper to send copies around, both for the companies and for pirates. But initially, the copying was not of great concern to the government or to copyright industry. As the court stated when the music industry, RIAA, challenged the Diamond Rio MP3 player, until recently, the internet was of little use for the distribution of music because the average music computer file was simply too big. The digital information on a single compact disc of music required hundreds of computer floppy disks to store, and downloading even a single song over the internet took hours. But because of compression technology and more bandwidth, we've now reached the day that the Diamond Rio court imagined. MP3's popularity is due in large part to the fact that it is a standard, non-proprietary compression algorithm, freely available for use by anyone, unlike various proprietary and copyright-secure competitor algorithms. And there we see the fact that something is freely available, helping it to gain market share, MP3 technology being the thing I'm talking about. Coupled with the use of cable modems, compression algorithms like MP3 may soon allow an hour of music to be downloaded from the internet to a personal computer in just a few minutes. And that's where we are today. I like it, but it's a legitimate concern for companies because it enables such wide-scale potential infringement. Yet in lobbying to protect their financial interests, the companies have been able to use this legitimate problem to shift the terms of the debate to an extreme amount. First of all, the copyright industries have convinced Congress to pass laws which make non-commercial copyright infringement a criminal matter. So this law basically, and their whole anti-piracy program in the past couple of years has shifted attention from stopping the large-scale commercial pirates to stopping small-scale, home-use, non-commercial copying. Okay? So these laws shift attention from the big-scale for-profit pirates to the little guy, and they also shift responsibility for the enforcement of the copyright industry's property rights from the industry to the federal government. So they've criminalized this non-commercial copying, meaning that not only that people will go to jail, but meaning that it's the public that foots the bill in order to enforce and protect the copyright industry's financial interests in stopping small-scale copying. Even with the backing of the FBI and law enforcement, they cannot count on catching everyone who makes unlawful copies. The federal government, despite what the law says, still really isn't interested in spending a lot of time and resources, which they have in limited amount, to stop the small-time non-commercial infringer or home user. So enter technology. If the law is not a perfect control over the small-time copier and how people use copyrighted works, then technology can be. With technology like SDMI, if it worked, and CSS, if it worked, the content industry can stop copying. They can enforce pay-per-listen schemes or limited time purchases. They can stop copying to a CD or to an MP3 player. They can enforce regional pricing schemes that make some people have to pay more money for DVDs than others. Technological methods, which are designed to control who copies a digital work and under what conditions they use it, are called digital rights management schemes, or DRM. Now, I want to say that DRM is important, but I also want to point out that it's not just about stopping copyright infringement. It's also about control. For example, large-scale pirates can just take DVDs and stamp blank DVDs with what's on the original, CSS encrypted, and sell the DVD like that. CSS doesn't really help stop DVD piracy. CSS doesn't really stop DVD piracy. What it does is it keeps control in the hands of the movie industry and lets them enforce their regional pricing schemes and decide what players you can play DVDs on. There are two main problems with DRM. The first problem bothers the record companies, and the second problem bothers consumer advocates, librarians, and scientists. The first problem, which bothered the record companies, is that the DRM technologies suck. SDMI is too easily defeated. A 15-year-old wrote a program that defeated CSS. So hackers can defeat DRM control mechanisms, and they can write tools which will let non-hackers defeat them as well. The second problem, the problem that bothers consumer advocates, librarians, and scientists, is that when DRM does work, it stops people from doing things that they want to do with their music, movies, and digital books. It also stops them from being able to exercise uses that they not only are used to, but that they're entitled to exercise under the law, fair use rights. So for example, if you bought music from the web, you can play it on the computer you used to make the purchase, but no other, under DRM. If you buy a DVD, you can't play it on your Linux machine. If you buy an ebook, you can't use your computer's read aloud function to read the book to you so that you can listen to it. Fair use is a long recognized exception to the fair use is a long recognized exception to the limited monopoly that copyright law gives to owners, inventors, and creators. Fair use is statutorily based, but it is founded in the principles of the First Amendment. People are entitled to make fair use copies of copyrighted material for purposes of comment, criticism, parody, scholarship, archive, backup. In any given case, courts evaluate whether a particular use is a fair use by weighing the purpose and character of the use, the nature of the copyrighted work, the amount and sustainability of copying, and the market effect. The most important factor in this analysis is number 4. If the infringer's use adversely affects the market for the original items, then it will be very difficult for him to claim fair use. And this makes sense because the whole idea of the copyright scheme is to incentivize creation, and that's what's at the heart of American copyright law. So they don't want fair use to undermine the financial incentive to the original creator. But what the law giveth, the content industries taketh away. When John Johansson wanted to play his DVD on his computer, he wasn't infringing any copyright, yet the CSS DRM scheme stopped him from doing it. When blind people want to use the read aloud function with their Adobe eBooks, they aren't violating any laws either, but DRM won't let them do it. Congress never considered a law that would prevent companies from blocking fair use, but maybe they should. Instead, what happened is that for a little while there was a battle of technology versus technology. Companies wrote DRM schemes, coders wrote programs that defeated DRM, and if people used those programs to make fair use of the material, great. If people used those programs to infringe, well, that was their problem, that was their offense, and the coders couldn't be held responsible. Until the DMCA. Passed in 1998, the DMCA incorporated provisions of the World Intellectual Property Organization Treaty into United States law. So what happens is, because we have this digital technology that enables copies to be sent around the world, the whole intellectual property scheme has become internationalized. And intellectual property debates are first hashed out before the World Intellectual Property Organization, which is a forum to which the rich copyright industry has a lot of access, but which librarians and scientists and consumer advocates do not, in the United States, do not have a lot of access. As a result of the WIPO, and the organization is called WIPO. As a result of the WIPO meetings prior to 1998, they institutionalized or they passed a treaty, and the signatories to the treaty were supposed to implement the elements of the treaty in their domestic laws. That is what the DMCA did here in the United States. The most controversial of the provisions from the WIPO meeting and in the DMCA is the anti-circumvention provision, or Section 1201. Under this law, as I said before, it's illegal to circumvent a technological protection of a copyrighted work, or to make or distribute a technology or service for the purpose of circumventing the technological measure. Now, I've simplified the law a lot, and I've lost a lot of precision in doing so, but I want to look a little more closely at some of the provisions, and maybe that will be a little more exact. So, the first part of 1201 prohibits acts of circumvention. After public debate, Congress built in some exceptions to this prohibition, most notably that nothing in this title would affect rights, remedies, limitations, or defenses to copyright infringement, including fair use under this title. Some people think that this means that circumvention for the purpose of fair use is not illegal, and we will see in the future whether courts adopt this interpretation of the law or not. During the debate on this provision, copyright owners argued that if you can't break into a library to make fair use of the books in it, then you can't break CSS to make fair use of a movie. So this was something that was very persuasive with the Congress, and maybe something that will also persuade judges. So I don't have a lot of hopes that this provision is going to be a meaningful and protective exception for the anti-circumvention provision. The problem is that the breaking and entering metaphor for circumvention activities is something that means a lot to people who are unfamiliar with the technology. So they use this metaphor to understand the technology, but then they begin to believe that the metaphor actually accurately describes what's going on, and they adopt that representation as both being scientifically equivalent and ethically equivalent with what's happening. There is an exception for security testing, but the exception is narrow. It applies to good faith testing, investigating, or correcting a security flaw or vulnerability with the authorization of the owner or operator of the system. The factors that go into determining if the exemption applies are whether the information derived from the security testing is shared with the owner or operator of the system, or is used solely to promote the security for the owner or operator of the system, not for third parties. It also depends on whether the information obtained from the security testing is published on the internet or distributed in some way that enables other people to use that information for either copyright infringement or for other offenses like unauthorized access under Section 1030. There is an exception for encryption research, and the exception is also narrow. It applies only to professional cryptographers. The researcher must also seek permission from affected rights holders before doing their research. The researcher must prove that the research was necessary to advance the state of the art, not merely to perform an experiment. I see a question.
What is a professional cryptographer?
That's a good question. I think what they mean, I think what the statute's trying to get at is somebody who's professionally trained in encryption, not an amateur who's home taught. So they're looking at things like people who have a degree. I actually have an office next door to a professional mathematician, but I think that if people who are familiar with the field of encryption know that, and cryptography know that a lot of great work comes from people who are amateurs and not people with a professional education in the field. And this was one of the great concerns. This is one of the great concerns that we have.
Are you going to talk about how they're applying it beyond anti-circumvention to all the other forms of security research?
Yes.
Okay.
She asked if I was going to talk about how it applies to other forms of security research, and I am. Okay, additionally, this exception for encryption research may be unavailable if the researcher publishes the results in such a way that potential infringers could get a hold of it. There's also an exception for reverse engineering of a program, and that exception is also narrow. It only applies if the sole purpose of the reverse engineering is to achieve program-to-program interoperability, and if reverse engineering is necessary to do so. Analyzing a program for flaws or to see if it does what it says it does is not included. The reverse engineer cannot divulge any information that he learns in the process except for the sole purpose of enabling program-to-program interoperability. Remember this because it's going to come up later. Many computer scientists and encryption researchers woke up to the danger of the DMCA when the RIAA threatened Ed Felton and his colleagues. Some didn't think that Section 1201 endangered computer security at all. Until recently, I was one of those people. In October, when a Linux developer announced that they would not be including information about security fixes in the latest release, I was quoted in Security Focus as saying, "The DMCA is bad, but it's not that bad." I was correctly quoted, but I was incorrect. Microsoft recently applied for a patent putting DRM technology into the core of the operating system. If DRM is built into the operating system, does any research or tool that circumvents the operating system also circumvent a technological copyright protection measure? If so, then the DMCA provisions apply. The question then is whether the security testing exception will protect security researchers, the people in this room and the people speaking at this conference, from prosecution or civil action under the DMCA. And the answer to that question lies in how broadly courts will interpret the exemptions in the statute for security testing, reverse engineering, and encryption research that I just described. We only have one court case in this area to guide us. In the DCSS case, the 2600 magazine case, Eric Corley tried to use the reverse engineering exception as a defense. Remember that the exception applies if the purpose of the reverse engineering is to promote program-to-program interoperability. Well, Johansson testified at the trial that he wrote DCSS to help Linux programmers write a DVD or create and develop a Linux-based DVD player. The judge in the case rejected the defense. He ruled that first, DCSS did not have as its sole purpose interoperability because it could be used to bypass CSS on a Windows-based system. Second, CSS might help achieve data-to-program interoperability, but the statutory exception only applies for program-to-program interoperability. And third, even if the exception applied, perhaps it would be a defense for Johansson, but it was not a defense for Mr. Corley, who was merely a journalist. If security testing and encryption research exceptions are also read as narrowly, many of the people in this room, people who practice full disclosure, people who make security auditing tools publicly available, people who write proof of concept code, are in trouble. As a result of the threats of legal action in the Felton case and the broad holding in the 2600 trial court, or rather its very broad interpretation of the DMCA's prohibitions, the world's first educational and scientific computing society, Association for Computing Machinery, submitted a declaration to the court saying that its members were concerned that its DRM workshop would be illegal, especially papers on watermarks, encryption, authentication, access control systems, tamper resistance, and threat and vulnerability assessment. I list these because I want to make it clear the types of information that the DMCA potentially applies to. Some news outlets reported that the IETF, the Internet Engineering Task Force, that its digital rights management research might cross DMCA lines. Because in building good systems, the group learns from breaking other systems, acts of circumvention that may fit under the DMCA. Did you have another question?
I could take it offline.
Okay, well, I'm almost done. Are these concerns of ACM and the IETF justified? Now I think they are. If DRM is more intimately intertwined with operating systems, and if courts continue to read the exceptions so narrowly, then there is serious cause for concern. I don't think that the statute can ever prohibit the distribution of pure information. I think that would be protected by the First Amendment. But in this field, the distinction between giving information and distributing a technology, product, or service, device, component is not clear, because information may come in the form of something like proof of concept code, which the law may see as a technology for circumvention. So I've raised some theoretical questions about how the DMCA will apply to the field of security research, questions that I cannot answer. The law is relatively new, and there have been very few cases interpreting these provisions. But the answers that we already have give us great cause for concern. While we wait for the law to catch up to where technology already is, the technology bounds forward and raises new questions about the effect that this law is going to have on computer science, security, and research. What to do? Perhaps the biggest obstacle to stopping statutes like the DMCA is not the power, or the money, or the persuasive rhetoric of the content industries. The biggest obstacle is getting lawmakers to understand what the hell is it that you guys do. And they need to understand why security testing is important, why we need reverse engineering, why these restrictions are dangerous. The lawyers need you, the computer security professionals, and the academics and the researchers to help us explain what is it that you do, and why is it that it's important, and how does this law endanger it, and why do you need to be protected? If you understand even a little about this law, you know much more than lawyers and judges know about technology. Don't throw up your hands and give up. You should give the rest of us, the non-technical world, what we need to know to see things more clearly. You can write papers for popular audiences or magazines. You can talk to lawyers who are concerned about the DMCA and similar laws and explain how these provisions affect the work that you do. You can submit amicus briefs in cases in courts and in cases that are in courts and ask judges to protect computer science and computer security research. You can also take the example that I have up on the screen and protest. We need your help in order to stop these provisions. What will you do? Thank you. Do I have time for questions? Yes. Okay, great. So I don't know if we're set up for questions, but if you say it so I can hear it, I'll repeat it so everybody can hear.
With the rash of new homeland security and anti-terrorism laws, where do you see things going?
The question is how I think the homeland security and terrorism laws will affect this. I think that in my mind, these are distinctive things. One is the protection of the intellectual property interests of these companies, and the other has a lot to do with more of a law enforcement sort of need. But I think that they do mesh and blur together because we're basically talking about how much we're going to protect technology that perfects control. And I think that those two ideas do go hand in hand. We're in a lot of, I'm very much a civil libertarian on issues of privacy. And I was a criminal defense lawyer before I worked at Stanford, and I still kind of am a criminal defense lawyer, maybe sometimes too often. And I am very concerned about those things. I think we've given, because of September 11th, we've given up a lot of privacy in the recent USA Patriot Act. And I'm very concerned about that. I think that there is a trend here, I think, maybe with the two of them, but in my mind they are distinct. They're distinct issues because there's different interests that we're trying to protect here. But we're in trouble in both fields. Other questions? Yes?
Is this
And the question is this also happening in Europe? And the answer is yes. Signatories to the treaty have to implement these laws. Right now, it's not happened because they don't have, I know that Europe doesn't have the DMCA anti-circumvention provisions yet, but anybody who signs the treaty will. And there's great pressure to sign these treaties because along with it comes a whole lot of economic benefits in terms of trade and that sort of thing. So we have both the WIPO Treaty and also the Hague Convention Treaty, which is coming up, that have to do with being able to enforce foreign judgments and sort of to smooth the way for business. But basically, as a result, it's sort of creates a kind of hegemonic kind of one interpretation of intellectual property that will lay over all of the United States and Western Europe and anyone who signs the treaty. So yes, it's internationalized, although they don't have this problem yet. Right here.
You said that Jesper Johansson is being prosecuted in Norway?
John Johansson, another Johansson, yes. He is. They filed charges against him in the middle of January last month.
And he said that they don't have the same kind of laws in Europe as we have in the United States. So what did they charge him?
The question is, what did they charge Johansson with in the DVD case? They charged him with a Norwegian offense, which is breaking into something in order to obtain data that does not belong to you. So essentially that he broke into the DVD to obtain the movie which didn't belong, to obtain access to the movie that didn't belong to him. I mean, I'm not an expert in Norwegian law, but to my ears it's an extremely strained interpretation of a statute that simply does not apply, but that is the offense that they charged him with. Eli? So the question is there a way to implement the WIPO Treaty that doesn't offend all these rights that I've mentioned? And I love questions like this because this question just symbolizes why my new job is so great. In the old days, being a defense attorney, I could get up here and I could say why it was wrong, but how to make it better, I just didn't really have the time to think about that. But now that I have this new job at Stanford, I do have the time to think about how to make things better. And I think the answer to that question is, to the question of whether WIPO can be properly implemented is yes. The DMCA provisions can criminalize anti-circumvention for the purpose of commercial copyright infringement. The criminalization should be defined, and the exceptions should be sort of the default. The way it is now is that there's a broad criminalization, and then they've tried to carve out little exceptions for each potential use that people could come up with and think about, and then tried to describe what a security testing exemption might look like, or describe what a reverse engineering exemption might look like. And in the narrow descriptions, a whole bunch of activity that we may want to protect and promote gets sort of caught up in the wash. We should take the opposite approach, and we should narrowly describe what's prohibited and let everything else be allowed. And that would conform with the WIPO provisions and allow us to still participate in the treaty. So thank you for asking me that. And thank you, Stanford, for hiring me.
Seems like not only did they carve out specific exceptions for specific uses, but they carved out specific exceptions for uses which the industry approved of. Because completely, for example, program-to-program compatibility rule, you killed individual effort. If I have somebody that I want to write a read-aloud program like Slyrock did, the only way I can possibly do it with program compatibility is actually to write a plugin for Adobe's ebook program, in which case I have to approach Adobe, get their approval, license it, pay them to use their term with my work. I mean, there's no way for an individual to do that.
Did everybody hear that question? Basically, Okay, good. So the question is, even the exceptions seem to be kind of industry crafted, and he gave some good examples of how that was true, and I think that's right. The exceptions are very narrowly crafted because there was debate over each exception, and you can see how narrowly crafted they are, not only in the example you give of having to go and cooperate with Adobe, but in the encryption research, you have to ask the rights holders for permission first. How are you going to do something like that? The other, and also they're very narrowly defined. In the security testing example, you can only reveal the information that you've discovered to the person whose computer security you're testing. You can't then go turn around and say, while I was doing an audit on this, I found, on company B, I found this vulnerability that all the rest of the company should be aware of and publish that on the internet. Suddenly that seems to maybe take you out of the security testing exemption. Another example of how narrowly crafted they are is that the fair use exception to circumvention, that sort of maybe it's a fair use exception thing that I talked about, doesn't have an exemption that lets you build a tool for that. So if you're accused of circumventing, you can say, well, I was doing it for fair use, but where'd you get the tool to do it? No one's allowed to produce a tool for the purpose of fair use circumvention. So those people who are skilled enough to write tools maybe will be able to have fair use, but the public at large will not. Security testing, reverse engineering, and the encryption research one do have a tools exception, an exception to that provision of the DMCA as well, but the fair use one doesn't, which kind of puts fair use just in the hands of the very few. So you're absolutely right. The exceptions themselves were the subject of great lobbying debate, and the librarians and scientists expended a lot of political capital and a lot of effort trying to think up all the situations in which an exception might be needed, and this is what we came up with. So, in the very back.
Microsoft, as you know, has just hired Scott Charney as the new chief security strategist. What do you think that the ramifications of having him in that position are, given that he's a lawyer, he prosecuted hackers while at the DOJ, and that Howard Schmidt is his best friend and now the #2 man in Washington? In regard to the enforcement of DRMOSs and the DMCA, what do you think the future of having someone like him in that position are?
Did you guys all hear that? Okay, the question is, what do I think are the ramifications of having Charney in the Microsoft position? And,
And I might quote you for a security focus artist.
I realize I'm being recorded.
And if you want to answer privately, that's fine too.
But it's still going in the article. I'm not a conspiracy theorist about these things, but just because it's not a conspiracy doesn't mean that they're not out to get me, right? So I think that there is cause for concern, and I see that as I'm seeing how the whole debate over full disclosure has kind of unfolded, and Microsoft's role in that, and trying to sort of rein that in and try to target who gets information about security vulnerabilities and to control that information. Then I look at the security testing exception in the DMCA, and I see that that also tries to control how information goes. Specifically about your question with having Charney involved, I think that's going to give Microsoft even more power with law enforcement and with the federal government. But in terms of what I see here with a trend, and this may be harder to quote me on in the article, there's a trend here towards security through obscurity or security through secrecy. And the DMCA anti-circumvention provisions are not a copyright law. They are a trade secret law. This is not balanced. It doesn't have anything to do with the First Amendment. It basically says certain classes or types of information are secret, and you can't distribute information about that. And so basically what it does is it carves out this sort of black area where people are not allowed to talk. And it says, because this information could be used to infringe on somebody else's property rights, even a qualified property right such as copyright, we're not going to really let you freely act in this area. So it's a trade secret. It's really more of a trade secret tact that they're taking. And I think that that has been throughout the information age very much a trend in law enforcement to prosecute Trade Secret Act cases, to prosecute copyright infringement even when it's not commercial, and to criminalize a lot of the activities of information seeking in the field of computer security, which lawmakers do not understand well. Well, let me see if somebody else doesn't. Yes.
That's kind of interesting. So this trade secret provision is, so if we know there's a flaw in an automobile or a drill bit or an MP3 player, we're not allowed to share that information based on the trade secret idea.
So the question is, under trade secret law, if we know that there's something wrong with a car or an MP3 player or a piece of software, does trade secret law prevent us from sharing that information? And I have to say that the law is not clear on this information. Now, obviously, Ralph Nader wrote that book, Unsafe at Any Speed, and we depend upon, consumer reports and reviews of products to tell us what we want to purchase and buy. It's essential to a free market to have information out there about the products and services that people are offering. Absolutely essential. And so how could those possibly be trade secreted or be trade secret protected? It doesn't make any sense. Yet, I have to tell you that I actually had a case where my client had some information about a vulnerability in a piece of software. And when the software owner, they contacted the company that produced the software and said, we've found this vulnerability, do you want to fix it? Get back to us by a certain time, we're writing a paper about it. And they actually responded to us and said, if you write a paper about our vulnerability, that is our trade secret. And you can't write that. You received that information from one of our licensees. Our licensees are not permitted to reveal our trade secrets. As an agent of the licensee, you are not permitted to reveal our trade secret. And the definition of trade secret is something which derives its value from the fact of being not generally known to the public. So I don't think this is what they meant when they wrote the statute, but it's vague enough that, it was arguable. We got the letter. Right. My answer is it should not apply, but I think that the way that the law is written and with the complexity of this area of the law, it has been argued. And I researched that, and there is not clear. The law isn't clear on it. I think in the end, you will be right that you can give out this sort of information, but especially because of the type of secrecy enabling laws that we have coming out, especially with sensitivity about software and copyright infringement and stuff like that. That's really, I think it's a danger. Certainly, I think you're right. I think you should be right, but I think it is a danger.
Well, it seems like a national security issue
To hide information about why something works poorly.
Right.
Yeah, it's a national security issue, and it's also it also has to do with greasing the wheels of capitalism. People can't buy the best product if they don't know what's bad. So pro-capitalism, thank you.
So there's hundreds of people finding hundreds of vulnerabilities and hundreds of products, and it gets released to bug tracking. The trade secret thing doesn't come up. What was different about that particular case that caused them to be able to say that as opposed to everybody else that releases security vulnerabilities?
So the question is, if you have bug track where vulnerabilities are released all the time, what's different about the case I was talking about that made that something where arguably you could argue it was trade secret? And I think the answer there was that the information was acquired through this licensee relationship was basically why they argued it. The reason why vulnerability information about Windows NT right now is different from vulnerability information about SDMI is because SDMI protects copyrighted material and Windows NT doesn't protect copyrighted material. So there's these very weird, fine distinctions in the law that kind of make no sense to people who are practicing in the field. The whole licensing issue is another issue with how we're going to treat the licensing of software and how much control the writer of software retains when the writer licenses software out to others. There's legislation that we're fighting over right now, which is UCITA, which deals with whether the sale of software or other sorts of computer information are going to be treated as a sale of goods. I sell you the program, you basically can do with it what you want, or whether it's going to be treated as a license where I can, where the contract between us is supreme, and I can make you give away any rights that I want you to give away and retain whatever rights I want to keep as part of the sale of the software. So licensing is another wrinkle in this whole thing that makes it more complicated.
So if Microsoft was
If Microsoft puts DRM in the OS, will BugTrack have to take all of those, its information about that OS out? And I think the answer to that is, I mean, there is no answer. But I think that's something we really have to be worried about, because I don't know if this security testing, like I said, I don't think the distribution of pure information can ever really be criminalized. But to the extent that information is presented, so I think the Felton case, for example, where they were giving a paper and the RIAA said, you can't give a paper, I think that was a pretty clear winner for them, because we're talking about some of the most important First Amendment speech, which is talking in an academic conference and giving pure information in a paper. But to the extent that information is given in anything that looks like code or a program or something like that, I think there's where we're really beginning to get into an area of concern for what the law may say and the law might say in the future. I'm going to, you.
Well, it's kind of funny you mentioned that. I mean, can you comment on the DCSS stuff where, I mean, you saw the T-shirts floating around and there were, you know, they created diagrams and flowcharts and things to kind of describe it, but didn't really put the code out there.
The question was about the DCSS shirts and whether those were illegal. And I think that there is law, some good law out there that says that not only diagrams about how DCSS might work, but also the source code could be considered to be protected speech, because source code is the way that programmers speak. Machines don't understand it. It's so programmers can understand what the program is saying. And there's a case in California, the Bunner case, and there was also the Bernstein case, which was an encryption export issue case in which the courts ruled that code had, even source code had free speech or speech elements in it that were protected by the First Amendment. So, we do have the First Amendment to fall back on, and that's why I say I think for pure information and even for something like source code, those may be protected. So I think people with the T-shirts can still feel comfortable going out. I hope so. But if anybody with a T-shirt gets arrested for something like that, please do call and let us know. The back.
That kind of brings up another question. What I understood you to say is that if something is brought up, if something is distributed in the source code, then we could actually use that to distribute as opposed to having a compiled binary?
What I'm saying is that there have been court cases that have ruled that source code has speech elements in it which are First Amendment protected. And so binary code does not, because humans don't use it to communicate with each other. That's how the computer uses it. But source code is a way that programmers can communicate with each other. Here's what the program is doing or saying. So courts have ruled in those two cases that I mentioned that source code has speech elements. And to the extent that that's true, the First Amendment will protect those speech elements to the extent the First Amendment protects speech.
Do you think this has any implications as far as defense information warfare research goes?
It has no implications for defense or information warfare or anything, because there's actually a very broad exception in the DMCA for national security and government interest, government security testing. And you can really see the difference, why I say it's kind of a trade secret law, when you look at, and I wish I had it up here on a slide, but I don't. But if you go to the DMCA, it's 17 U.S.C. 1201. And if you look at the exception for government use and government security testing, and compare that to the security testing exception for the rest of us, you can really see that they almost understood how important security testing is. They just don't want to let us do it. It's okay for the government to do it, but it's not okay. It's not okay for private sector. And because it is very broad. So I don't think it has those, the government was very successful in lobbying itself for its own powerful exception. So I think we're okay there. Am I done?
Sure.
Okay. Thank you very much.
You started late, so.
Okay. Am I done early or late?
No, you're done 5 minutes later.